Hi everybody, welcome to Module 4. And this is the second part where we'll be talking about our responsibilities as therapists and our clients' corresponding rights. Overall, we're going to be talking about largely confidentiality and privilege, and especially the limits to confidentiality like mandated reporting or situations where your client threatens harm to themselves and others. And specifically, we'll talk about the Tarasov case this week. I know it was probably a difficult time reading it. It may be the first time you read a legal case, but I'm glad if you struggled through it. And we'll be practicing that skill throughout the semester. We're also going to talk a bit about supervision and the supervisory relationship and about consultation relationships. Excuse me. So to begin with, confidentiality is one of the most basic elements to the counseling relationship. It's the foundation and the trust that our clients put in us in order for them to be able to come in and disclose things that they probably wouldn't even disclose to their closest friends. So in order for them to be able to do that, we have to be able to ensure them a bit of privacy, a bit of confidentiality, and I'll talk a little bit about the difference between those terms and also testimonial privilege in a little while. But in addition to telling clients about confidentiality, it's also important that they have a clear idea of what the limits to that confidentiality might be. So we do this through the process of informed consent, which we've talked a bit about already, but I'm going to go through again in a little more detail. Because it's important that the clients understand these limits and that you also understand your responsibilities in relation to these limits. So first, I want to talk a little bit about the difference between privacy, confidentiality, and testimonial privilege, because these are three things that often get used interchangeably, and they're definitely interrelated, but they're not quite exactly the same thing. So privacy is the broadest of these, and it's actually considered a fundamental right. And if you read the Constitution, you'll notice that it's not in there. But the Supreme Court has found it in what they call the penumbras of the other elements of the Constitution. And what they mean by that is that some of our other rights wouldn't mean very much without the right to privacy. So that's the broadest of the three concepts. And in large part, our right to privacy is what's referred to as a negative right, which means it's the right to pretty much be left alone. Some of the privacy rights that we have are a little bit more active than that, but in large part, the right to privacy is a negative right. Confidentiality is a bit narrower than that, and for our purposes in clinical situations, confidentiality refers to our agreement with our clients to keep the information that they have given us private. So we have a duty to keep the information private, and correspondingly, our clients have a right to confidentiality. The third concept that's often confused with that's within confidentiality and even narrower than the ideas of privacy and confidentiality is that of testimonial privilege. And most people just refer to this as privilege. And what this refers to is basically your right to keep information private within a legal proceeding. So if the court, for example, orders the therapist to disclose information and the client doesn't want that information disclosed in court, then the client can ask the therapist to do what's called asserting their privilege. And then the court makes a determination whether it's more important that the information be disclosed or that we protect the privacy of the therapeutic relationship. And which way that'll go really depends on the facts and circumstances of the case. The only exception to that is when clients have brought in their mental status into the legal proceeding on their own. For example, if they're suing for damages that are the cost of therapy as a result of an incident that occurred, so now they've had to undergo therapy, the court won't then allow them to keep the information regarding their therapy out because that's key to the matter and they've actually raised the issue as part of their lawsuit. with regard to confidentiality, you have an ethical duty under the ACA code, under the APA code. All of the codes discuss confidentiality in one way or another. So you have an ethical duty, but it's important to note that confidentiality is not absolute. So there's not always a right to confidentiality for patients. So in the informed consent, you want to be letting your patients know that you might be forced to disclose information in certain limited circumstances. And then we'll talk about a few of those. The first being mandated reporting, the second being threats of harm to themselves or others. And those are probably the two most important situations, especially for you to know what your responsibilities are and what the standards are and the circumstances under which you can disclose information. So generally, there are a couple situations in which confidentiality is a little more complicated. And one of those is if you're doing groups or working with families or working with couples. In those situations, while testimonial privilege statutes require or allow you to assert the client's privilege and not to disclose information in court, group members, for example, don't have the same responsibilities. So testimonial privilege statutes don't cover them. So while you can review at the beginning of the group the importance of confidentiality between group members, there's no way for you to really assure to those group members that, for example, one of the group members could be called into court and compelled to testify about what's occurred in the group. With regard to mandated reporting, one of the most important things, and I won't belabor this because I know that we covered it in orientation and I've actually posted those slides as well with the exact statutory language. But I think some of the most important things to remember are that it's a requirement when you encounter things within your professional role. So if you're just out at the park on a family outing and you notice something, that's not a mandated reporting situation. And generally it applies to three groups of people. So kids or juveniles, the elderly, and disabled dependent individuals. So that's largely maybe people who are MR, for example, and dependent on others for their care. You're required to report to the appropriate responsible state agency, and all the state agencies are included in the slides that I've sent to you. And I'm going to stop right now, and then in part 2 of this video, we'll talk about threats of harm to self or others, and TARASOF and the different ways you can discharge your duty, and a bit about informed consent, supervision, and consultation. See you in a couple minutes.